Welcome to our tutorial lessons on the law of tort, episode 11. You may recall that during our 10th episode, we treated the defenses to intentional tort and defenses involving torts committed against one's property. In today's episode, we are treating the rule in RYLANDS and Fletcher. Let's start by looking at the historical background of the rule in RYLANDS and Fletcher. The rule in RYLANDS and Fletcher is a fundamental principle in tort law, particularly in liability arising from the escape of dangerous substances or things. It emerged in the 19th century from the landmark English case RYLANDS and Fletcher, which set a new precedent for determining liability in cases involving damages caused by activities on neighboring properties. The facts of the case are as follows. Mr. Rylands, a mill owner, had a reservoir constructed on his land. Due to the negligence of the contractors hired, the reservoir was built on top of disused mine shafts connected to Mr. Fletcher's coal mines. When the reservoir was filled with water, it eventually burst through the abandoned shafts, flooding Fletcher's mines and causing extensive damage. The House of Lords that held that Rylands was strictly liable for the damages incurred by Fletcher. What is the purpose of the case? The case's judgment created the foundation of the rule in RYLANDS and Fletcher, which became an essential element for determining liability in circumstances involving the storage and use of hazardous substances or materials that could potentially cause damage if they escaped from the defendant's property. Blackburn J. in his judgment said, "What is the obligation which the law casts on a person who, like the defendants, lawfully brings on his land something which, though harmless while it remains there, will naturally do mischief if it escapes out of his land?" We think that the rule of law is that the person who for his own purposes brings on his land and collects and keeps there anything likely to do mischief if it escapes must keep it at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of his escape. Before looking into the elements flowing from Justice Blackburn's judgment, a good illustration of where the rule will apply was seen in Cox and Burbridge, where William J. said, "I apprehend the general rule of law to be perfectly plain. If I am the owner of an animal in which by law the right of property can exist, I am bound to take care that it does not stray into the land of my neighbor, and I am liable for any trespass it may commit and for the ordinary consequences of that trespass, whether or not the escape of the animal is due to my negligence is altogether immaterial." Thus, according to Street, a person who in the course of a non-natural user of his land accumulates or is held to be responsible for the accumulation on it of anything likely to do harm if it escapes, is liable for the damage to the use of the land of another, which results from the escape of the thing from his land. What then are the key elements required to establish the rule in RYLANDS and Fletcher? For the plaintiffs to successfully apply the rule in RYLANDS and Fletcher, they must prove the following 5 elements. 1. Non-natural use of land. 2. Escape. 3. Dangerous substances. 4. Accumulation. And 5. Foreseeability of damage. Let's now take these elements and examine them seriatim. Non-natural use of land. Lord Keynes, on appeal in RYLANDS and Fletcher, established that the use of land must be an unnatural use. That the defendants must have used their land in a manner that deviates from its typical or natural use. This includes activities or construction that pose a risk of potential danger to neighboring properties. For example, storing large quantities of industrial chemicals or constructing a reservoir on a residential land space may be considered non-natural uses of land, whereas common residential activities or growing crops on farmland are considered natural uses. As rightly held in Reed and Lyons, carrying on an industrial duty is not putting land to an unnatural use. in an industrial society. Similarly, in Rainham Chemical Works Limited and Belvedere Fish Guano Company, it was said that the manufacture of ammunition during wartime was not to be regarded as an unnatural use of land. Thus, what is unnatural was determined in Richards and Lothian. Lord Moulton stated that it is not every use to which land is put that brings into play that principle. It must be of some special use, bringing with it increased danger to others, and must not merely be the ordinary use of the land or such use as is proper for the general benefit of the community. In summary, to constitute an unnatural use of land, there must be special use of the land, the use must bring with it increased dangers, and they must not be the ordinary use or use for the general benefit. The courts have interpreted natural to mean something which is ordinary and usual, and the vice versa will be non-natural use. See also Vanderpoel and Pioneer Shoe Factory Limited. The second element we'll be looking at is escape. Damage must have been caused by something escaping or flowing out of the defendant's land. The escape should have come from the land under the defendant's control and caused damage to the plaintiff's property or interests. In the Rylands and Fletcher case, water escaped from Rylands Reservoir and caused damage to Fletcher's coal mines, satisfying the escape element of the rule. In explaining what is meant by escape, Viscount Simmons and Reed and Lyons held that escape, for the purpose of applying Rylands and Fletcher, means escape from a place where the defendant has occupation of or control over land to a place which is outside his occupation or control. This serves as a further check on the application of Rylands and Fletcher. See also Pouting and Noax, where it was held that the horse was poisoned, but the tree which the horse got poisoned from did not escape. In summary, to constitute escape, the thing must move from a place, the defendant is the occupier of that place or has control over that place where the thing escaped from, and that it must escape to a place which is outside his occupation or control. The third element we'll be looking at is dangerous substances. This element answers the question, what are the things considered under the rule? The rule applies to materials or substances that are considered dangerous, meaning they can cause harm if they escape the defendant's property. This extends beyond toxic or hazardous substances and can include anything that poses an abnormal risk when allowed to escape. Example of dangerous substances or the things under the rule may include water, gas, explosives, electricity, chemicals, or even vibrations generated by machinery that could potentially damage neighboring properties and humans, that is, caravan dwellers, as held in Attorney General and Cork. The fourth element we are going to be looking at is accumulation. Justice Blackburn talked of a person who, for his own purposes, brings, collects, and keeps there the thing that causes the mischief or that caused the mischief. This means that the rule will not apply to things which accumulate or grow on the land naturally. See also Pontadar, Rural Council, and Moore Gwine, Dublin and Ghana Housing Corporation. The last element is foreseeability of damage. The defendant must have been able to anticipate that the escape of the dangerous substance will likely cause harm to neighboring properties. This element is based on the reasonable foreseeability test, whether a reasonable person in the defendant's position would have anticipated the risk of harm. In Cambridge Water Company and Eastern Counties Leather, it was established that the foreseeability of damage of the relevant type should not be regarded as a prerequisite of liability in damages under the rule in Rylands and Fletcher, meaning the action would not succeed if the defendant had not known and could not reasonably have foreseen that the thing will cause the contended consequence. What then is the extent of liability under the rule? The defendant is liable for any injury to land because of the escape of a thing, as well as consequential damages. Unless the thing escaping causes damage, no action will lie under this rule. See the case of Jones and Festimog Railway Company. See also Musgrove and Pandelis, where it was held that there is liability for consequential injury to chattels. Thus, to successfully apply the rule in Rylands and Fletcher, all these elements must be proven by the plaintiff. It is crucial to understand that the rule is based on strict liability, meaning that the defendants may be held liable regardless of whether they were negligent in their actions or not. The next thing we'll look at is capacity. Generally, to institute an action under the rule, a person must have interest. In Weller and Food and Mouth Disease Research Institute, it was held that the plaintiffs could not succeed under the rule because they did not have an interest in land affected by their escape, and that the plaintiffs could not recover damages under the rule in Rylands and Fletcher because they had no interest in the cattle endangered by the escape of the virus, and the loss suffered by the plaintiffs was not a sufficiently proximate and direct consequence of such escape. Contrast this case with a decision in Halsey and Esso Petroleum. Lastly, let's look at the defenses and action in Rylands and Fletcher. To start with, reference can be made to Blackburn J in Rylands and Fletcher. There he said, he, that is the defendant, can excuse himself by showing that the escape was owing to the plaintiff's default, or perhaps that the escape is a consequence of vis major or the act of God. Thus, this sentence contains three possible defenses, and these are: first, consent voluntarily given as affirmed in Peters and Prince of Wales Theatre. Second, the act of third parties. Here, liability is excluded if the escape is caused by the deliberate, unforeseeable act of third parties. But if the defendant could have foreseen or prevented the act of the third parties and did not, then he is liable. See Richards and Lothian and Box and Jab. In the latter case, the defendants were held not liable for damage done through an overflow from their reservoir, because the overflow was caused by an act of a third party who emptied his own reservoir into the stream which fed the defendant's reservoir. See also Perry and Kendricks. Third, the act of God. If an escape is caused through natural causes and without human intervention, circumstances which no human foresight can provide against, and of which human prudence is not bound to recognize the possibility, then it is said that this defense is available. That's in Nichols and Mankind, where a most violent thunderstorm caused flooding, the defense succeeded. In Rack and Williams, Baron Bramwell made a statement which is perhaps a rough guide for this defense. Talking about an extraordinary storm, he said, "We call it extraordinary, but in truth it is not an extraordinary storm which happens once in a century or in 50 years or 20 years. On the contrary, it would be extraordinary if it did not happen." There's a French saying that there is nothing so certain as that which is unexpected. In like manner, there is nothing so certain as that something extraordinary will happen now and then. So in Greenock Corporation and Caledonian Railway Company, an extraordinary and unprecedented rainfall was held not to be an act of God. The House of Lords explained that in Nichols and Marsland, the jury had found that no reasonable person could have anticipated the storm, and because the court did not want to disturb the jury's finding, that is why the defense succeeded. This is the end of our 11th episode. We hope you learned and you will join us for our next episode on the law of tort. Please help us share this channel to every single person. Like our videos, comment, and subscribe. Thank you.